Hey, everybody, we've got some breaking news. We're coming to you live from our radio studios because this has just happened this afternoon. I mean, just moments ago. A big win. I mean, a fantastic win in a case that you're all aware of, and that is the case that we've had against the Internal Revenue Service for targeting conservative organizations. You'll recall that this started in 2010 where the IRS had their Be on the Lookout list. Their idea there being, of course, that if you were a conservative organization, if you were a pro-life organization, if you were an organization concerned about constitutional conservatism, you were targeted for a treatment different than anybody else. Remember this from Lois Lerner in May of 2013 when she was caught in this whole scam targeting the IRS. Take a listen.
They used names like Tea Party or Patriots, and they selected cases simply because the application had those names in the title. That was wrong. The IRS would like to apologize for that.
Very interesting here. We filed a federal lawsuit against the Internal Revenue Service, alleging that their apology does not cure the constitutional violation. That, in fact, the IRS engaged in discriminatory viewpoint discrimination against conservative, pro-life Christian organizations and just some conservative educational groups. To place it in context, let me read from you what the court said. The court said viewpoint-based discrimination is based on the specific motivating ideology or opinion or of the prospective speaker, and therefore plainly offends the First Amendment. Now, we allege that the application process itself was, in fact, discriminatory. The court was faced with the trial court dismissed the claim that we brought initially, saying that it was mooted out because the IRS had ceased doing this. What was interesting is, of course, and I'm holding the letter here, and this is referenced, by the way, in the opinion. We've got a letter from the Internal Revenue Service on April of 2013. And in that letter, for those of you watching right now on Facebook and Facebook, Periscope, and, of course, on aclj.org, this letter actually is one of the examples the court uses in saying this discriminatory practice has been going on now for 6 years and that it has not, in fact, ceased. This is what's so significant here. The court, and I'm reading from the opinion here, says we therefore require that the district court, allow the case to move forward on the constitutional claims. Now, why that is significant is that we've alleged, and we were, of course, here end up being successful, that the IRS was engaged in real discrimination, targeted discrimination, discrimination because of the viewpoint here of conservative individuals and organizations. The IRS acknowledged that they were violating our clients' views, but said they stopped. We knew that they had not stopped because, as I said, that case is still outstanding, folks, 6 years later. The court was fully aware of that. Here's an example of what the court said on page 18 of the opinion regarding the IRS's activity. And this is what the court said. The IRS basically is putting the organizations in what the court referred to as this catch-22. Quote, we've been violating your rights and not properly processing your applications. You are entitled to have your applications processed. But if you ask for that processing by way of a lawsuit, then you can't have it. The court then says, we advise the IRS, if you haven't ceased to violate the rights of the taxpayers, then there is no cessation. You have not carried your burden, be it heavy or light. The IRS further attempted, the court notes this, to justify the lack of cessation as some of the applicants it refers to in this catch-22 because of a long-standing policy of the Department of Justice and IRS that once a case is placed in litigation, they stop processing the applications, which, of course, the law doesn't allow them to do that. To this, the court says, we advise the IRS, if you haven't ceased discriminatory conduct, the fact that you have been failing to cease it for a long time does not create cessation. You still have not carried your burden, be it heavy or light. The court remanded the case now back to the trial court. We're on Facebook and Periscope live right now. Logan's with me in the studio. If you've got comments or questions, we are going to be willing to answer those and talk about this. Obviously, on Monday's radio broadcast, we're going to get into this in great detail. But the beauty of being able to go live on Facebook and Periscope is we're talking to thousands and thousands of you right this moment. This is a major win. I've got more to discuss here, but Logan, let's let people know how they can communicate with you to get questions in on that.
That's right. Right now, I'm checking out Facebook. I'm going to be checking Periscope as well. Just ask questions. If you have any specific question regarding this, feel free to take it. Again, just put in a comment like you would a regular post. There's so many coming in right now. I would ask you if you'd limit them to the questions right now. So I'm glad you are putting in, yes, that you support this, and that's fantastic. But if you could put in just specific questions, give those a little bit of rest just for a second so I can monitor.
I do have to say, I just saw a good one here. Logan said, any win is a good win. Let me tell you about that, folks. This is better than a good win. This comes, by the way, on the heels of a unanimous Supreme Court of Georgia decision we won just last month at a court of appeals on defending the state of Georgia on a child obscenity, where they prosecuted for child obscenity, and it was challenged. We won that case, defending the state's right to prosecute these child pornographers. Now, really a month later, not even, we have this big win at the IRS. So
we do have a couple questions.
Yeah, let's start a game and share it with their friends so we can get this out to as many people as we can.
One person just asked, is it retroactive?
Yes. Great question. So not only is it a litigation that's retroactive in the sense that we still have 2 clients that actually have their applications pending, but what we alleged in the complaint was that there were ongoing violations from the moment the application process started. It's called viewpoint discrimination. These groups, and we know this because the IRS said it, we'll get some more of these comments from Lois Lerner, these apologies and these Fifth Amendment statements, but it's retroactive in the sense that even the cases where we did get the clients their tax-exempt status, Logan, the court said even those clients may well have had their rights violated with this viewpoint discrimination, and their actions can proceed. So all of our clients, and let's find out, I think it was 34 or 36. Let's see if we can ask Miles Terry, who worked on this as well, how many ongoing cases. I think there were over 30 cases of this. It was interesting also, the court said that, this whole idea of this longstanding policy doesn't undercut the significance of a constitutional violation. But realize that the Obama administration, the Obama administration's IRS was arguing that it did. And remember when the commissioner of IRS promised everybody this had stopped? Well, this court says it hasn't. And this is a 3-judge panel, Court of Appeals, the court right below the Supreme Court of the United States.
A lot of comments are coming in asking, what does it mean for the IRS? Are there any consequences to their action? And what does this turn out to be?
So here's what happens. The case now goes back to the district court. We will be moving to proceed with discovery, which means we'll take depositions, interrogatories. The case is clear. I mean, here's what you got. The government was trying to get out of this on a technicality because, remember, they admitted that they violated the law here. I mean, they said that from the outset.
A lot of people just joining us. Maybe just give a recap.
Okay, so here's what we've got. A decision has come out this afternoon, and obviously we're coming to you live on Facebook and Periscope and through our website. In the United States Court of Appeals for the District of Columbia, that's the court right under the Supreme Court of the United States. It's our case against the IRS. I'm holding it here, Logan. I don't know if they can get a decent shot of this because I know it's with the lighting.
It's there.
But there it is. There's the opinion. So it just came out. This is a 3-judge panel. We took an appeal because the district court dismissed a lot of our actions, saying, well, it was mooted out because some of the organizations, most of the organizations, we were successful in getting their tax exemption, which was not true to all of them, by the way. There were 2 still outstanding. But the Court of Appeals said that the IRS's ongoing constitutional violations here could proceed to trial or proceed in litigation at the district court because, and I think this is the critical part of this, folks, the IRS never stopped its discriminatory practice. And the fact that they said, well, we stopped processing some of these applications simply because you were in court, the court said that in and of itself is in fact, not a justification for this. And it warned the IRS, and it warned the IRS twice. At first it said we would advise the IRS that a heavy burden of establishing what's called mootness, which is the case is over, is not carried by proving that the case is nearly moot or is moot as to a vast majority of the parties. Their heavy burden requires that they establish cessation, not near cessation, cessation. In other words, that the discriminatory practice had stopped. And the court then said the IRS offers a rather puzzling explanation for why the continued failure to afford proper processing to at least some of the victims' applicants should not prevent a finding of cessation. The court talks about a catch-22, saying that they were involved in litigation and therefore we stopped. The court then went on to say that that is not a justification at all. In fact, quoting from pages 17 and 18 of the opinion, the court said, and again, for those that are just joining, and I know there's thousands that are, can I read these 2 again, Logan? Is that all right?
Sure, I think so. You can recap.
Yeah, because for those that just joined us, it's a 20-page opinion, so it's a thorough opinion. But here's 2 things that I think are 2 key quotes. The government argued that the case was moot because some of our organizations had received tax exemption. Now, let me play it for you again. Lois Lerner. This is her hearing. This is her testimony. Correct? Is that from her testimony? This was on May 22nd, 2013, when she said she did nothing wrong.
I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations, and I have not provided false information to this or any other congressional committee. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right
not to testify or answer questions related to the subject matter of this hearing.
All right, so to that point, when she talks about I've done nothing wrong, the court completely disagrees. The court says the IRS offers a rather puzzling explanation for why the continued failure to provide proper processing, at least for some of the victim applicants, should not prevent a finding of what's called cessation. Again, cessation is a technical determination that has the unconstitutional act stopped. We alleged it hasn't. They said it kind of has. The court said that's not good enough. We win. That explanation is that the organizations whose applications were still pending were involved in litigation with the Justice Department. And then the court said the IRS's brief further illuminates this point with a footnote explaining that under long-standing procedures, administrative action on an application for exemption is ordinarily suspended if the applicant files suit. In other words, we're not going to process your application, even though we're required to under law, simply because that, you filed a lawsuit, therefore we don't have to. Basically, we filed a lawsuit, we have to stop. The court said no. The court made this clear statement. It is not at all clear why the IRS proposes that not ceasing becomes cessation if the victim of the conduct is litigating against us. And then it says the IRS puts the individuals in a catch-22. Here's what the IRS is telling the applicants. This is from the court's opinion directly. We've been violating your rights and not properly processing your applications. You are entitled to have your applications processed. But if you ask for that processing by way of a lawsuit, then you can't have it. We would advise the IRS, this is the court again, if you haven't ceased to violate the rights of the taxpayers, then you've not ceased to violate their rights. You have not carried your burden, be it heavy or light. Then the IRS tries to justify its unconstitutional activity by saying that it's a long-standing policy. This long-standing policy that if you file a lawsuit, we stop. Here's what the court said. To this, we would advise the IRS, quote, if you haven't ceased discriminatory conduct, the fact that you have been failing to cease it for a long time does not create cessation. You still have not carried your burden. So in other words, the fact that you didn't change your policy is justification for us to move forward in the constitutional claims. And by the way, it is the constitutional claims that move forward here, which is very, very significant. I know we got a ton of questions coming in.
Yeah, but a lot of questions are just kind of can be summarized. A lot of people said, what does it mean to them as the everyday citizen? Also, if you could just kind of give a layman's term version of this, because I know it's a bit heady for people that don't understand.
Okay, so here's what happened. We filed suit because the IRS had what was called a BOLO list. They called it a BOLO list. Be on the lookout. If you had Tea Party in your name, if you had conservative in your name, if the word Constitution was in your name, if the word liberty was in your name, you were put in a special category. And basically, for years, these applications for tax exemption were not processed, which had impact on political speech, on free speech. I mean, if you can't imagine if the conservatives did this to the left, they'd be going crazy. I mean, this would be, discrimination, unconstitutional. Let's get the Eric Holder bite, where he said the IRS conduct may well be criminal. This is from Eric Holder, the Attorney General of the United States. So we've got this bite. So to put it in context, this became big news 2013 when, in fact, it became public that the IRS was targeting these individual conservative, Christian, pro-liberty groups. Here's what Eric Holder said.
I have ordered an investigation to be begun. The FBI is coordinating with the Justice Department to see if any laws were broken in connection with those matters related to the IRS. Those were, I think, as everyone can agree, if not criminal, they were certainly outrageous and unacceptable.
Of course, then the IRS administration, by the Obama administration, defends what he called outrageous and unacceptable and maybe even criminal. If not criminal, certainly outrageous and unacceptable. And then they did nothing, and they had that fake investigation. Well, here's what it means in layman's terms. We are now allowed to proceed against the IRS in federal court on the constitutional claims. We allege that our clients' First Amendment rights to freedom of speech, freedom of association, remember those ridiculous questions that they were asked, who you prayed with, who you talked with, that all of that was a violation of the Constitution. So the good news is we now get to proceed in federal court. So we'll have a full analysis on this. We got a lot of information posted on the websites. I know that already. There'll be more out. And, of course, on Monday's radio broadcast, we'll get more. If there's any more questions, I'll be happy to take them, Logan, or else we could say a great way to go into the weekend. That's for sure.
Absolutely. There are other questions, but I think a lot of them are covered with what you had to say. So I appreciate everyone who has sent in a question or comment. Periscope, let me take a question from you. I haven't taken any.
Yeah.
Give me a question. Someone throw one out there on Periscope. We'll answer one or two, and then we'll wrap this thing up. I'll give it just a second.
Yeah,
here.
let me say this also, that you've been standing with us for a long time on this case, and we've been litigating this case for almost 3 years. And it's been tough. I mean, we did get a number of the groups their tax exempt status. But Logan, you remember even a friend of yours, I won't give the name of the organization, was kind of swept up into this thing, and they were an educational group. And nothing to do with conservative politics, but they had something in their name or description.
Yeah, people asking, what's next, and what do you think happened to Lois Lerner?
So the great Lois Lerner question. Well, I mean, we could take her depositions. Believe me, I don't think this started with Lois Lerner. I've always said that. I think she was the mid-level of this. I think this goes much higher up. She'll take the Fifth Amendment. She's not going to testify, but we will now be able to get discovery from the courts. We'll go after other individuals. If she takes the Fifth Amendment, it's an admission against interest. We can't proceed against her individually because they are immune because they're government employees. But we're able to take the IRS to court, and it's the Obama administration IRS that is now going to be litigated in the U.S. District Court.
Well, can I take this last question? What's the timeline like? What would be the next step?
Well, we could have, it could be as early as Monday that we get what's called a scheduling order from the district courts. I'm sure the court's going to set up a scheduling conference. We'll probably have to do some additional briefing at the district court level. We're going to ask for immediate discovery. We'll probably want to amend the complaint again. There's been a lot of information since we filed this lawsuit, and we will proceed. Remember, it was Judicial Watch just last week got additional information out on the IRS situation where they found out that, in fact, exactly what we thought, that the targeting did not start in 2011, that it actually started in 2010, and that it started at the top. Folks, I think this came from Chief Counsel's Office of the IRS, maybe higher up. Remember all those visits to the White House by the IRS commissioner and Lois Lerner? What were they talking about? Tax code revisions? Let's get real here. So I think the end of the day, look, this is a huge win. We're thrilled. We're going to have a further analysis on this on Monday on the broadcast, but we wanted to be able to, that's the beauty of being able to do this on Facebook and Periscope and on our website, able to come to you literally immediately, and we've been able to do that. So with that, I'm going to say it's a great way to go into the weekend. We'll have more information for you on Monday. Also, we'll post information on Facebook and Twitter and get information out that way. But get everybody, share it with your friends, let everybody know. It's going to be hard to get it on in the news because it's the week. These decisions come out Friday at 4 o'clock in the afternoon. But we got to it as very quick as we could. I want to thank our entire staff for getting this up today. So, and again, and thank all of you. Really, the truth of the matter is, without you, we couldn't be doing this. And, we're in the middle of our matching challenge campaign for this month, really, just the first week of the month August here. And I can't think of a better way to start. So your support of the ACLJ makes a huge difference. But again, a huge thank you to everybody. Thank you to our team. We had a great team that put this case together, and just thrilled with the outcome of how this case ended up. So with that, have a great weekend, everybody. We'll talk to you Monday.